Getting a divorce can be complicated and emotional. It's hard enough when a relationship ends. Going through the divorce process may only make it harder. This video will guide you through the basics. You'll learn about when you might need the professional help of a lawyer or a mediator, and when you can complete a divorce yourself. If you're a parent, you'll also get a sense of what the courts can ask before a divorce will be approved. The first thing to know is that only people who are legally married can get a divorce. If you were never married, your process is somewhat different. Under Canadian law, there are 3 ways a divorce can start: when a couple has lived separately for at least a year, when a spouse commits adultery, or when one spouse is physically or mentally cruel to the other. Adultery and cruelty must be proven, and if this applies to you, you should seek legal advice. So, should you handle your divorce by yourself? Do you need the assistance of a mediator or a lawyer? It is useful to get at least some legal advice while you are going through your divorce. In Alberta, many family lawyers will offer a free 30-minute consultation. Call 1-800-661-1095 for a lawyer referral. It's a good idea to familiarize yourself with the divorce process before you call, so you can ask specific questions about your situation. Ask about legal fees. It may cost a lot more than you expect. And if you have a low income, you may qualify for legal aid. You may find it difficult to locate a lawyer able to assist you, or you may not be able to afford a lawyer. If you or your spouse cannot agree on how to go forward, mediators can play a very important role. Professionally trained to diffuse tense situations, they help people work out disagreements together. Since both parties use the same mediator, divorce costs can be less expensive than arguing through lawyers. If you or your spouse has income under $40,000 and you have a child under the age of 18, you may qualify for free mediation from Family Justice Services. There are also a number of private mediation options available. You can contact the Alberta Family Mediation Society or the ADR Institute of Alberta for a list of family mediators. During mediation, you and your spouse may meet for just a few sessions or a number of sessions. When the mediation process is successful, you and your spouse may receive a written agreement. If you don't have a lawyer, you can copy parts of this agreement into your divorce paperwork. The mediation agreement is not legally binding until a judge approves your divorce paperwork or it is ordered by the court. If you choose to self-represent, that means you will be responsible for filling out your own divorce forms. You can find these forms on the Alberta Court's website or purchase a divorce kit from the Queen's Printer. The printer publishes laws and law-related documents. All divorces begin and end with paperwork. The first step down the road is submitting or filing a statement of claim for divorce to the Court of Queen's Bench, either in person or by mail. This document will ask you for things like the reason why you want a divorce, details about child custody and child support, even spousal support. A stamped copy of this statement of claim must then be delivered to your spouse, who the court now describes as the defendant. So you or your lawyer must then find another adult to deliver the statement of claim directly to your spouse. That person swears an official statement for the court declaring that they served the papers to your spouse. Your spouse will then have a deadline to officially respond by filing court documents. Divorce rules are strict. If the paperwork is not filled out exactly right, it will be rejected. Help is just a visit or phone call away to a nearby Family Law Information Center. Now let's get into the issues that must be sorted out when couples just can't agree. We'll start with property. There's the obvious stuff, cars and trucks, furniture and the family home. Then there's the not so obvious, things like bank accounts, investments, and pension plans. You won't just get to claim the good side of the finances, the assets. You may have to take on the bad side too, the debts. If one of you wants to fight the split in court, you'll definitely want to seek legal advice or a mediator. You may be entitled to more than you know, even if you don't have a lot of assets or investments. There are deadlines for starting a court claim to divide up your property. You and your spouse will likely have to exchange your financial information too. The court often calls this financial disclosure. This means you have to provide copies of information about your income, your assets, and your debts. Without a doubt, the hardest part of a divorce is deciding what will happen to your kids. To help you better understand the effects of a breakup on your children, Alberta's legal system requires that you and your spouse attend a free seminar called Parenting After Separation, but you don't have to attend together. There are 3 main areas that divorcing parents need to resolve concerning kids: custody, access, and support. When you have custody, it means you're responsible for a child's physical care and that you get to make important decisions about how to raise them, such as their education and religion. A parent with the exclusive right to raise a child has what's known as sole custody. Most parents choose to share decisions regarding their child, though, otherwise known as joint custody. Certain details must be ironed out for joint custody to work, like where will the child stay and how often? Will it be weekends with one parent, the rest of the week with the other? Or will parents simply alternate weeks? All of the decisions a judge makes will be based on the best interests of the child. Even when a parent does end up with sole custody of a child, the other parent, the non-custodial parent, may still have a right to visits. This is called access. Parents on good speaking terms can set up their own access schedule. If you have concerns, though, about violence or abuse towards yourself or your child, it may impact the custody decision that the judge makes. There are many resources available to assist you with these concerns. By law, both parents must provide support to their kids after a divorce. Every child has the right to adequate food, shelter, schooling, clothing, and medical treatment. The judge's order will always take into account the number of children in need of support, the amount of time the children spend in each home, and each parent's income. In Alberta, judges base support on federal child support guidelines. You can find out more about them online at www.justice.gc.ca under the Family Law tab or by contacting your local Family Law Information Center. When a split is likely to leave one spouse much worse off than the other financially, a judge may approve spousal support. Here, the judge takes into account the impact of the marriage breakdown on each person's finances. Like child support, spousal support is partly based on income. Unlike child support, spousal support may not automatically be ordered. Divorce can be complex and intricate, and everybody's situation is different. That's why getting legal advice is always recommended. Even if you decide to self-represent in your divorce, remember, you can arrange for mediation or seek further legal advice at any time to help you through any portion of your divorce or to complete it. For more information, contact a Family Law Information Center.